Afternoon, everyone. I would like to welcome you all to today's webinar on global patent protection strategies and the way forward. My name is Shubhangi Thakur, and I'm an innovation specialist at AGNI. AGNI stands for Accelerating Growth of New India's Innovation, and it is one of the 9 missions of Prime Minister's Science, Technology and Innovation Advisory Council. So what we primarily do is, if you're a startup, we help you get market access with the industry. And if you're a startup looking for scaling support, the AGNI team also assists with that, from connecting with the relevant funding channels to offering the necessary manufacturing support. So if you would like to be a part of our portfolio of innovations, you can apply on our website. And at the same time, if you're a corporate who's looking to, deploy innovative technologies in your industry across different sectors, our team would be happy to, support you in this endeavor as well. So if you'd like to know more about the program, I would request you to log on to our website, which is www.agni.gov.in. So on that note, like I mentioned, the session for today is on global patent protection strategies, where we will talk to our expert for the day regarding why is global patent protection strategy important, what are the different types of strategies that exist, at what stage should a startup apply for a global patent, and what are the steps and procedures involved for the same. And this webinar is a part of a series of webinars that we conduct with our esteemed partner, CPAM, which stands for Cell for IPR Promotion and Management under Ministry of Commerce. Now, may I please request Diksha Arora from CPAM to kindly tell us about the kind of work that CPAM's been doing for IPR awareness across the country, and also please introduce the expert for today. Over to you, Diksha.
Shubhangi, thank you so much. I welcome everyone once again. We at CPAM, when I say CPAM, it stands for Cell for IPR Promotion and Management, which is a body that has been formed under the Department for Promotion of Industry and Internal Trade, that is DPIIT, Ministry of Commerce and Industries, New Delhi. With the adoption of the National IPR Policy in the year 2016 by the Government of India, a step was taken forward to promote innovation and creativity and be able to provide a strong IPR regime in India. We at CPAM, we work towards spreading awareness among the people at large about the importance of IPR and the different ways with which we can safeguard it, and also be able to do the same. We have been conducting various workshops and seminars on IPR for students at schools, colleges, and universities. We have also been working towards sensitizing authorities like officials from police, customs, and judiciary. Industry, which forms a very important part in building the economy of a country, and realizing that we have been taking various initiatives to promote IP in industries. And this initiative of joining hands with AGNI is one of them. We have been conducting a series of IPR events focusing on different clusters. And today's session is a part of these series of webinars that have been planned together by CPAM and AGNI, wherein we will be discussing about the details about the global patent protection strategy and the way forward. Without delaying it any further, I would like to welcome today's speaker, that is Dr. Vijay Kumar Sahu, who is a regional manager and head of Intellectual Property Facilitation Center in Technology and Innovation Support Center, Visakhapatnam. Mr. Sahu has won National IP Award from Government of India in the year 2020 for his outstanding contribution in IP and innovation. He has been an eminent speaker on various IP forums and has been a part of various national and international IP seminars and events. We welcome you, Mr. Sahu, and we really hope that today's session is able to enrich people and give them all the detailed information that they should be knowing about global patent protection strategy. I would now request Shubhangi and Sahu sir to please take this forward.
Thank you, Diksha, and thank you once again, sir. It's indeed an honor to have you here amongst us. And I'd like to welcome you all and welcome you and especially all the audiences that have joined us today. So before we begin the session, I would request all of you, if you have any questions during the session as well, please post it on the comment section, and our team will try to answer most of the questions during the session and towards the end as well. So to begin with today's session, I'd like to start with, asking the expert for the day, Dr. Sahu. So Dr. Sahu, considering the sort of expertise you have and the kind of copious amount of experience that you've had in IPR so far, why do you think it is important to have an international patent protection strategy? And why should an innovator and a startup be aware about it?
Thank you, Suvangi, for this beautiful program. And as you know, we are in the changing paradigm of innovation ecosystem, and we are in a global village under the roof of WTO. When we are talking about innovation, value creation, it is a high time for all of us to knowledge must be acknowledged. So intellectual property is one of the tool to acknowledge the inventor and creativity and innovation. And in that global scenario, many invention innovation are coming from various geographical location. So there should be a benefit sharing. The inventor must get his right or must get her right over his creativity and invention, what the intellectual property we have. So it is the high time, because but there is a changing paradigm of innovation ecosystem, and intellectual property is playing a very, very important role in the knowledge system. And today our ecosystem is nothing but a ecosystem of the knowledge, and that knowledge ecosystem now moving toward creative innovation and creativity. And now we have been talking about industry 4.0.
Thank you, Dr. Sahu. Which brings me to the next question: is what should a startup consider when deciding to pursue patent protection outside India? And what would you recommend, sir, with your expertise and your experience, at what stage should a startup or an innovator file for an international patent protection?
Subhangiji, I would like to tell you and apprise you that in India, our ecosystem of IPR is first to file, first to protect, and we must have to take the priority. So the person who filed first, he get the priority. So when we are talking about intellectual property as an intangible asset, we must have to protect fast. We must have to do the due diligence fast before venturing into the market. We must protect and have a strategy of protecting our intellectual property, and which is intangible asset today. And that intangible asset make the difference in the global economy.
Right, sir. So, like you talked about, how there should a startup or an innovator should have a strategy in place before applying for an international patent. So, sir, what are the global strategies that you could probably tell us about that, the startups and the innovators could keep in mind so that they make a timely decision and a well-informed decision of applying for an international patent?
Yeah, Subhangiji, intellectual property is a legal right, legal in nature. And there is a both criminal jurisprudence and also civilian jurisprudence is there. So it is the high time for all the startup entrepreneur, as far as the intellectual property is concerned, when they are because intellectual property is, since it is a legal right, legal in nature for a startup, because startup itself is a new entities. So if that new entities will be going to any litigation, how he will mitigate that litigation? Because once the case goes to the court, it will be difficult for a startup to mitigate such kind of challenge. So better we must prepare and gear up to protect our intangible asset. Then we move ahead as far as to the market economy.
Right. Thank you, sir. And sir, would you like to give some example of certain global strategies that our Indian startups could keep in mind before they actually go out in the international market and apply for an international patent?
Particularly, the global strategy is nothing but the strategy we have, that opportunity of protection of IP right through mechanism, and that mechanism today we have already adopted, and that is that is called PCT mechanism, Patent Cooperation Treaty mechanism, under the WTO, and India is a PCT member country. There are, I think, more than 173 countries are PCT member country, and it is an umbrella system. And in that umbrella system, all spoke are country and all spoke are national phase. So once you apply this umbrella head in a resident country, and you can choose to respective country where you want to protect your patent, and that will goes to the national phase. And PCT application is the best way for filing a patent application globally, and that strategy is a need of the hour. At the same time, we have a traditional kind of regional system where you can directly file the patent in that country, but there is a cost effective issues are there that we must have to look into that. And since we are discussing about startup has minimum the budget. So how we can do a due diligence and make a strategy that the startup should get as much as benefit in protecting the IP wherever he is going to venture the business in the market, so that he can have that kind of freedom to operate in that country. And that is the need of the hour for the startup to look that kind of strategy, and particularly in the intellectual property protection.
Brilliant. Thank you, sir. So now that Dr. Sahu, we understand what's the importance of an international patent, we also kind of understand, the global strategy that probably the startups should, keep in mind before planning and before expanding into international markets. So what are the multiple ways that, a startup or an innovator can file for the international patent?
There are, yes, as I told, multiple ways. There are two ways. One is PCT route, patent cooperation treaty route, and another is a regional route, directly filing in that country. But let me also tell you the cost. The most important issue is the who will bear the cost, and that strategy we must have to look into that. And we are fortunate that we have a startup and stand-up India ecosystem where CPAM or Agni Invest India are playing very important role, particularly through our SIPP scheme. So point we must have to understand, when we are going for a protection of intellectual property, the cost and the mitigation of the cost first, and also the due diligence, because patent act of various countries are different. So we must have to understand, like in India, software is not patentable in India, or software is not coming under the invention. So, but software embedded with hardware is patentable in India, but in US, software can be a patentable. And also we have to see, because somebody is investing and there is an opportunity for that process and product in the market, there are various tools of intellectual property today. In India, we have patent. In other country like US, there is a utility patent. They have a patent as well as they have a utility patent. We have to look into that aspect, which patent we should adopt, so that we can reach on right time and mitigate the challenge as far as the managing of intellectual property is concerned.
Correct. Thank you, sir. Thank you so much for, that brilliant overview of, international patents. So, sir, now that we understand, of course, there are costs involved and there are multiple ways that, startups can file for the patents. One way is the regional way, and one way is directly, applying for the international patent. So, what are the websites or the organizations that these startups can actually go and file for these patents? So, sir, first is for the regional area, and second, sir, for the global area. What are the websites or what are the steps or important organizations that startups should know about where they can register? And also, sir, if you could throw some light on what are the costs involved in terms of, so that, the startups can plan well in advance, because, of course, budgeting is one integral part of, growing the business.
Yes, I'll start with, as you asked, what are the agency and what are the website that is put in place. First, I will start with our country. India has a beautiful website, Government of India. It's called CGP, Controller General of Patent, Trademark and Design and Copyright, under Ministry of Commerce and Industry, under DPIIT. The website is ipindianic.in. And let me also inform you that India is designated as an International Search Examination Authority, International Patent Examination Authority. We have also the international ecosystem of intellectual property administration in India. We have 4 intellectual property office at Kolkata, Mumbai, Chennai, and Delhi. And we have very well professional officer who are looking after the international search authority and examination authority, and that information is available in the website. Anyone can go, and also anyone can reach to any controller to get the input. And today everyone are ready to provide a mentor, particularly in IPR, because there is a cost issues, there is a legal issue, there is a technical issues. We must have to mitigate such kind of challenge and advice to the startup, because for a startup may need some venture funding, and for a venture funding, somebody might be from abroad, might be putting some money, but he will see whether that product or process is novel or innovative is not, or are you that startup may be infringing other intellectual property, and infringing intellectual property is the greatest damage to the startup and greatest damage to the nation. And today you might be knowing that India has been kept a priority watch list by government, US government, called Special 301 provision before India. So these are the challenges, and these are the challenges we must have to look into that, and we must have to guide and provide a mentorship support to startup, entrepreneur, scientist, researcher who are going for protecting intellectual property. And other than this, we have USPTO website, we have espacnet.com, we have China intellectual property. They have also a beautiful website with English font. So there will be, we have a website. In every country have their own intellectual property website, and we have a beautiful website WIPO, and you can do a patent search through patent scope of World Intellectual Property Organization. Even for that, WIPO is playing a very important role for the patent cooperation treaty, for the international patent application publication that is available online for everyone, which is accessible, which is adaptable, and which is available for each stakeholder of the knowledge economy.
Great, thank you, sir. And sir, like I said, the second part of the question, what are the costs involved? If you could give us some examples, the costs in India, the costs abroad for an international patent, or certain examples of countries, if you could give us, what are the approximate costs that startups should keep in mind before planning to expand their business in the international market?
So Vangiji, as far as the cost, various country has a various fees, and that too in dollar. And for a Indian rupees, there is ultimately certainly one of the challenges for a startup for paying in dollar. So in my presentation, I have made it a PPT in that the country-wise fees structure. And normally, some of the country like India, Austria, their fees structure is very reasonable. And I will not say comfortable. Normally, we go with that because of the adaptability and also how we can pay in a comfortable way. But there are fee structure up there, and that also I have made a presentation on that, and that I will give you in detail, because I may not be able to give concretely during this discussion.
Sure, absolutely, sir. So, sir, these are the questions, and for the audience's reference as well. So these are the set of questions, in global patent protection strategies that we've come across in our experience of, interacting with innovators and the startup ecosystem in general, which is the reason why, we wanted to start with today's webinar with these questions, so that, all the audiences can get a context to what today's webinar is about, and of course, hear it from the expert himself, so that, we can actually plan well in advance as to what this strategy should be, what are the things we should keep in mind, and the costs involved. So, sir, before you can maybe, tell us and share your presentation with us and tell us about the costs and maybe certain global strategies, examples also in detail, are there any sort of, would you like to give certain concluding remarks to, this discussion on, just giving like certain takeaway points for all our viewers today who've joined us, that what are the kind of, important points, and very briefly to tell them, the things they should keep in mind before planning their global patent protection strategy?
Yes, certainly. I have my one submission to our startup leader here and all the stakeholder of our knowledge economy. When you are venturing to a business, the future is foggy. So first protect your intangible asset, that is intellectual property. and do a freedom to operate as far as your new process and product is concerned. So you must not infringe other IP in the market, because intellectual property infringement is greatest damage to the individual startup and also greatest damage to the nation at large. Because we must have to respect IP, we must have to leverage IP, we must have to collaborate for IP and commercialize IP, and that is our mandate of CPAM, Agni, and organization like NRDC to connecting with you all.
Thank you. Thank you so much, sir. Now, may I now please request, sir, if you could maybe give us examples, of course, through your presentation about certain global strategies that the startups can learn from. And at the same time, the websites, like you said, they're more detailed and the costs involved. So if you could cover these three topics and, sir can show us a presentation. And right after that, we can take up questions. So the audiences can put their questions in the comments section and we can take them up accordingly. Over to you, sir.
Okay, so shall I go for presentation?
Sure, sir. So you can share the global patent protection strategies, any sort of examples if you want. And at the same time, you can tell us about the website and the costs, like we discussed. So things obviously we couldn't cover in the session.
Yeah.
Thank you.
I hope my PPT is visible to all of you. So how we can create IP, how we can protect IP, how we can commercialize IP, and how we can make a strategy for IP to protect in other country, so that our IP must be respect. And infringement is one of the biggest challenges as far as the IPR violation is concerned. And we have seen many cases of Indian IP and Indian product were also protected in other country. So today we have to first to protect. We must have to make a strategy to adopt how to protect, where to protect, why we'll protect as far as our new process and product is concerned before venturing to the market. So as for the WTO, as for the World Intellectual Property Organization, patent is an exclusive right granted for an invention which is a product or a process that provide a new way of doing something or offer a new technical solution to a problem. A patent provides protection for the invention to the owner of the patent for a limited period time, that is 20 years. So the definition is clear. So we must have to look, and since our objective is for the startup and how startup make the strategy to protect their intellectual property in abroad, that we have to discuss, deliberate, and also come out with a solution how we can give a shoulder to them in protecting their intellectual property. Friend, I would just like to inform you that the scenario of international patent application by country in 2005, you can see from the slide, US was number one with 46,879 patent, and China was number 10 with 2,503 patent application. Internationally, this is I'm talking about. And Japan, Germany, France, all there next to US. So the time today, if you'll see in the paradigm shift of innovation ecosystem, today China is number one globally in international patent application as a country with 58,990 and ahead than US, Japan, Germany, and Republic of Korea. And our position is still not in top 10 in the global patent application or international patent application as a country. So these are some of the things we must have to understand, realize, because that what kind of strategy we should adopt, how we can build the confidence and capacity of our stakeholder to protect their intellectual property. We must have to mentor them, provide them a appropriate support. We have an excellent enabling ecosystem on this through our various flagship program of Government of India. So as far as the global strategy of protection of IP, I'll start with this slide. And this is the report of Association of University Technology Manager, how a intellectual property benefiting society and economy at large. And you can see the invention, innovation, and licensing of the intellectual property with product development and also public use and economic growth of the nation and making the difference to the international ecosystem of innovation. So this is something I thought I should share with you, how intellectual property we have to create. We have to do a due diligence, and also we can market it with the new process and product through licensing, and also create impact to the nation and international innovation ecosystem. So let's come to the point, the myth of global IPR and enforcement. So friends, there is no word called global patent, but there is an international patent. That international patent we talk about the PCT through WIPO, and PCT is Patent Cooperation Treaty, and that is under the regulated through the World United Nations World Intellectual Property Organization, and all patent rights are country-based right. So intellectual property right is the right of the state and legal in nature, and there is no word called global patent. So we must have to clear, and we must have to look into that, and there is no court with global jurisdiction. So that we have to understand, and the ecosystem of filing a patent for a startup, we have the two route. One is regional route, another is the PCT mechanism, which enable us to file a single application or patent application in all member country, so that we can connect the dot in going through the national phase application, we called it as. So there is no international or global patent, that I wanted to tell you in this forum. So the global development of intellectual property and benefit sharing is clear from this all the international negotiations. Since we are talking about global patent and strategy, we must have to look into the strategy and also international system of intellectual property ecosystem, because the ecosystem comes from International Union for Plant Varieties, International Union for Plant Genomic Resource, the Convention of Biological Diversity, the access to benefit sharing. We have in 1995, WTO has come in place. Under the TRIPS, the IPR come into the picture, the trade-related aspect of intellectual property rights. And these are the international development of IPR. So before taking any strategy, we must have to understand in which country, in which mechanism we are going to protect our patent. And also we must have to understand the international treaties, because we may be adopting some plant-based invention that we may be doing, or maybe some microorganism, maybe some issues related to plant and animal and also others. So that are the important issues we must have to understand, and through various international mechanism. And in fact, I would like to tell you, at this pandemic time, there was a global development and also deliberation of intellectual property or the patent issues related to the how patent is making a difference, particularly in the monopoly of the product and process. But in that, the WTO plays a very, very important role, and also mitigates such challenge today. And there was a negotiation and international issues, as well as the international ecosystem for mitigating the challenge of bilateral issue through WTO system, because that rules that is under the WTO, the TRIPS has come, and under that, the TRIPS particularly covers copyright related issues, that to right of performer, producer of sound recording, broadcasting organization. You know, copyright is one of the challenging issues today, and also there are issues related to many piracy and of illegal activities of copyright. Second is trademark, including service mark. Third one is geographical indication, including appellation of origins. Fourth one, industrial design. A fifth one, patent, including protection of new varieties of plant, the layout design of integrated circuit, undisclosed information or trade secret or test data. These are the area as of intellectual property that has been deliberated globally, and also part of our TRIPS agreement. or TRIPS negotiation, and that talks about the standard enforcement and dispute settlement of intellectual property. So in that, I would like to tell you that internationally, as I told, there are few convention of protection of intellectual property. In 1833, there was a convention called Paris Convention, and in that year, particularly 1833, 11 countries were entered into the force in 1834. But today, around 173 countries are the member of Paris Convention. The objective of Paris Convention, as far as the global scenario of intellectual property, I would like to inform you, is national treatment, parallel importation, right to priority, independence of patent, protection against false indication and unfair competition. The total number of nations, particularly in this Paris Convention, is 173, and the main objective of this Paris Convention is obtaining, maintaining, and enforcing industrial property to the member country as far as the Paris Convention is concerned. But there is a cooperation came, and that cooperation is Patent Cooperation Treaty, or PCT, and that has been harmonized under the UN institution, under the World Intellectual Property Organization, where there are around 153 member countries are there, and that PCT today we are talking about the patent application through PCT route, and that will goes to the member country, 153 member country, where we are looking for opportunity of commercialization of our IP through national phase. And in that national phase, the inventions come from a regional system of IP, and goes to international application, and the nation patent office is the receiving office, and that will transmit into a international search authorities or international authorities for patent examination. And the International Bureau for the PCT is World Intellectual Property Organization, who publish the patent. Once that published, you can also designate your patent patent in the respective country where you are looking for opportunity for commercialization of your technology or invention. So this is one of the most important opportunity for through patent cooperation treaty to protect or make the strategy through this PCT route, where we can reach to each nation through national phase of application. So patent cooperation treaty is a one-stop shop for parallel filing in several states. This is one of the most important point we must remember. And filing with receiving office, every country has the receiving office. Like in India, our Indian Patent Office is the receiving office, and the Paris Convention priority may not claim or not, because Paris Convention is nothing to do with that. Because in Paris Convention, around 173 member countries are there, but in Patent Cooperation Treaty, around 153 member countries are there. And this is the controlled by World Intellectual Property Organization for preliminary search, examination, and also amendment of the claim for which we are filing for patent application, and that goes for national phase administration through National Patent Office. So today, as far as I told, PCT is one of the route for protection of intellectual property in a professional manner, time manner. So we must have to look for the why we are, what kind of strategy we should adopt globally when we are going for filing a patent. So there are many factors need to be considered when we are deciding for foreign filing or foreign patent application. First one, do we competitor have business outside? Why are we seeking patent protection? And what is our budget? Because budget is most important at the end of the day. For this all, there is a process of fees, and in fact, it has been asked for what are the schedule of charges for various process for examination, then publication, and also various amendment. There are various fees are there, and also what is our timeline, and do we have competitors, have business outside? That is, these are the four important issues we must have to understand as far as protection of patent globally, and we have to see the strategy for that. So basic of international filing strategy is that how big is the market for our invention in a particular country, that we have to do a due diligence, the market survey from a independent agency. How big is the market for our invention in a particular region? Where are the major manufacturing center for you and for your competitors? Where are the emerging market? Would a defensive patent be valuable? Do you have any limited time, or do you have any limited fund to spend on foreign patent protection? And what is the status of patent application in the foreign country of interest? Would your invention be considered novel in your country of interest? Where are your competitor filing their patent application? And can holder of patent right realize tax advantage in foreign countries? So these are some of the strategy we must have to adopt. Before filing a patent application, we must do a due diligence. First due diligence is patentability due diligence, whether our invention is patentable in that country or not, because intellectual property or patent law is specific to the jurisdiction and the country. So that we must have to understand. And also, what are the market we have, because at the end of the day, we are going for making a payment for various fees of the patent application in that country. So these are some of the most important strategy we must look into, and also we must have to do a due diligence, and we must have to look for filing a suitable way to protect our invention in that country in an affordable manner. And also we have to see the tax benefit, because in India we have a tax benefit like any other country. Is there any tax benefit? Accordingly, we should prepare and also grab that opportunity of tax benefit. So we have national filing, we have a regional filing, and we have a mechanism for PCT filing. Already national filing is nothing but filing patent application in our patent office, Indian patent office. We have 4 patent office. One is Delhi, Mumbai, Chennai, Kolkata. Kolkata is the head office of patent, since we are discussing about patent. And also regional office is nothing but directly filing our application in the country concerned where we want to file. Or we may also look for opportunity to file the patent application in multiple countries. In a single application is nothing but the patent cooperation treaty filing. So these are the 3 advantages of filing strategy as far as the patent application in nation, in any specific country, or in multiple country. So these are the opportunity and advantage of filing of the patent application. So one of the most important issues we must have to understand is the invention has immediate international market. What kind of strategy we should adopt? The most important strategy for this invention has, particularly as we understand that there is a market potential of our invention in that potential country, we must have to file the application in India, expedite in obtaining a foreign filing license from Indian Patent Office. After receipt of foreign filing license, we must have to file in countries of interest that are not member of the Paris Convention, or file a PCT application designating all PCT countries within 3 months after the national filing. And within 12 months after the national filing date, pay designation fees of desired country and proceed with PCT prosecution. And then within 12 months after the national filing date, file national application or the national phase of application in non-PCT countries that are Paris Convention countries. So this is the invention that has an immediate international market. We can go for that strategy. Invention has international but not global market potential. So if it is known ahead of time which country have market potential, one could file a PCT application designating country as of interest, including India, if filing in any Paris Convention non-member countries it desired, obtain a foreign filing license and file the application upon receipt of the foreign filing license. And within 12 months after the PCT filing date, pay designation fees and proceed with the PCT prosecution. So within 12 months after the PCT filing date, file national application in non-PCT countries that are Paris Convention countries. So we must have to understand today that the provision of Paris Convention and provision of PCT filing, because around 173 countries are the member of Paris Convention, and also in PCT there are around 153 countries. In that we have to see the market potential of our invention when what we are going to file in that country. So where to file? So general technology, the neutral strategy is ultimately EPO. Almost always we look for that thing. Huge market and economics, China, Japan, Korea and India. A large market and economies, Brazil, Russia, Taiwan and Mexico. So no translation required market is Canada, Australia, New Zealand and South Africa. So point I wanted to say you is that many of the in China we need translation fees. We can Japan also, we in Korea also. So even so that is very important, and that strategy we must have to understand, and also we have to prepare for that the budget for filing in that country and by seeing their market potential of our invention. So as far as the technology specific core filing, software, European Union, Australia, Canada, energy, European Patent Office, semiconductor, European Patent Office and others, life science, European Patent Office and other countries like Brazil, Canada, China, industrial chemical, European Patent Office and others, and also medical devices is European Patent Office, China and others. So these are the technology specific core filing of the country, those country who are very specific in protecting the intellectual property in the form of patent in a strategic manner, that we need to look into that and create that opportunity for filing the patent as per the market opportunity and also opportunity of the finance, because the fee structure is there, and that fee structure also I'm going to talk about. So cost and timeline for patent application, we must have to understand the cost and also timeline so that we can get benefit and minimize the risk and also get much more opportunity to directly link to the market. So if you'll see the country-wise US, the cost for filing and prosecution is from $15,000 to $50,000. Timeline for grant of patent 3 to 7 years. Europe 15,000 to $50,000, 3 to 8 years. Australia 7,000 to $8,500, 2 to 3 years. Brazil 10,000 to 80,000, 10 to 18 years. China $15,000 to $20,000, 3 to 5 years. India $7,500 to $15,000, 5 to 7 years. Japan $7,000 to $12,000, about 3 years. Mexico $12,000 to $15,000, 3 to 5 years. New Zealand $1,500 to $4,500, 1 to 2 years. Russia $10,000 to $15,000, 2 to 3 years. So this is one of the most important issues we must have to understand: time and cost. And for a startup, both matters. So we have to do that kind of due diligence and mitigate such kind of challenge as far as the cost of filing and prosecution of the patent, and also timeline for grant, so that we can mitigate any challenge during any kind of infringement or IPR violation. But let me also tell you, once you file a patent, you have the priority, but you must not, the patent must not reject in due course of time. That is also one of the most important issues. So the global challenge for patent today patent issue is that the examining the scope of patent protection across jurisdiction, specific disclosure and industrial design requirement, the impact of front, that is fair, reasonable and non-discriminatory licensing mechanism and patentability concern for technology including software, artificial intelligence and blockchain, and exploring the complexities and risk associated with the pooling patent and providing standard license. And once a patent has been obtained, consider the option of licensing the technology. License not only provide a source of revenue to the patent holder, but also means for setting a litigation matter. By offering license, dispute can be settled. So the most important takeaway for protection, global protection and strategy for patent protection, we must have to understand, and we have to see and also do the due diligence for the inventor, or we have to understand the inventor citizenship or the applicant citizenship and residency well before first filing, to give yourself to time to get a foreign filing license if necessary. Second most important issue is violation can range from fine, invalidation of patent, up to criminal liability. That to sanction include imprisonment up to 5 years, that to in Germany, 7 years in Russia, and 15 years in France. And third most important issue is the requirement are fact specific. If in doubt, reach out to a specialist for each country. So most important for startup and entrepreneur or anyone who are going to file a patent application, they should take the advice of specialist, IP specialist of that country or attorney, I will say, so that they guide properly, mentor properly. But there is a fees for taking a private mentorship. But there are many government organizations who, like us, who are providing mentorship to the startup and entrepreneur in protecting their intellectual property, so that they must not they must be ready to mitigate any such challenge and should protect their intellectual property when they are venturing to the business, to the market. So friends, by seeing all these international issues of the challenges and opportunity for patent protection, we must have to strengthen our ecosystem of innovation, particularly in India. And innovation is a long-term health of economy. So we need a healthy root system. So it is a high time for all of us to connect with academia, where the new innovator, inventor, researcher are there in protecting their IP, helping them in creativity and invention, and also skill and idea generation. In that, we have to make a sensitization. And today, sensitization is very, very important as far as the IPR is concerned from the grassroots level, so that people in higher level will understand and also mitigate such challenge. And that ecosystem we need to create so that we can have a healthy root system to mitigate such challenge and due course of time. So India needs more invention, India needs more innovation, because our intellectual property index, particularly when we compare with China, Korea, Taiwan, and America, we are much more behind. So we have to develop that framework and create that momentum, so that people should create and protect, and then we can commercialize that. So there is certainly a opportunities of intellectual properties is there for MSME and startup, and that momentum we have to create. We have to mentor them, because we have to mentor them professionally, so that they will able to understand technical issues, legal issues, and also ethical issues as far as the intellectual property is concerned. Because intellectual property particularly is time period is there, so that they can manage and mitigate and also pay the respective fees on due course of time. That is very, very important today. Other than this, we have to sensitize our women workforce, and we have a women scientist program, Kiran, under Government of India of Ministry of Science and Technology, Kiran IP program. So that these women scientists are now playing a very, very important role in guiding to and also mentoring to startup, academia, industry, and the knowledge organization, in protecting the IP and also providing a support. And this kind of programs certainly and this kind of opportunities certainly create more impact of creating more IP in the country, because IP awareness is need of the hour, and that we have also seen in the recent parliamentary committee report on intellectual property. So intellectual property is connected to research and development, and we must have to integrate. The integration is lacking. So in that integration, we have to protect and look for commercialization so that we can create some tangible asset from intangible asset. So we must have to integrate intellectual property into our business practice and organizational activities in the human resource, marketing, strategy, and finance, so that we can mitigate many challenges. In particular, in the human resource, we build capacity building on intellectual property so that all our technical people, anyone who ever might be, understand IP, respect IP, create a brand for IP, goodwill for IP, and also that will give the supremacy in the field of economy and position the institution or organization in the market, and also create a competitive advantage in, and also plays a very, very important role in merger and acquisition. And that's the need of the hour as far as the protection of patent globally, and that strategy we must have to develop, and also we must create a balance sheet of IP valuation and also IP monetization. So these are all important issues. We need to adopt IP, integrate our IP into a business practice. This is all about the global patent protection strategy from my side. Thank you, Agni and Sipam, for giving me this opportunity. God bless you. Jai Hind.
Thank you so much, sir. Really, really appreciate you taking us through the intricacies of global patent protection strategies, giving us insights and examples of how it's done across the world. So, sir, moving on to the question and answer session. I'd request the audiences once again, in case you have any questions, you can post on the comment section and our team will get back to you and we'll try answering all of the questions. However, sir, we have one question already that says that some technologies are simply not patentable in certain jurisdictions. So what are the examples of certain technologies that are not patentable outside India? So, for example, we know that softwares are not patentable in India. So, could you give us some more examples of technologies abroad that are not patentable?
Yes. As far as software is one of the example, but there are other technology. Now we are talking about blockchain technology. Now we are the emerging technology. Now in the nanotechnology, and India particularly, I like to tell you that we have a nano mission, but the protection of intellectual property for nanotechnology is we have to make a provision and also examination process. So every patent office has a examination process for particular sector of technology. And in India, we have a computer-related invention, and that has been Government of India has put in place. And same way in other country, we have in the African countries the issues of patent related to biological species. In India also we have a issues of in the herbal and herbal technology. I will say herbal technology or Ayush technology, because that has been must be clear and take permission from National Biodiversity Authority. Other than this, the traditional knowledge. India is the one of the hub of traditional knowledge, and in India traditional knowledge is not patentable, but in US our own turmeric was patented in US. So India fought that case. So we must have to understand. So if it is not patentable in India, it doesn't mean that it will be not patentable in US. So that strategy and that mentor, as I told, we have to take a expert from that country, from an institution who can have some kind of responsibility and liability to promote the invention and innovation, so that a person can guide properly to mitigate such challenge for to a stakeholder. That is very, very important.
Correct. Thank you, sir. And I hope that answers your question, audience. The other question that we have is what is the difference between patent protection and trade secret protection, if there is any?
Yes, Subhangi ji, let me answer you first that in India do not have a trade secret law. We are under we have 1972 Contract Act. Okay, so that rule related to trade secret activity, but India do not have any specific trade secret law. So other country they have its trade secret, and you know the example of Coca-Cola, and Coca-Cola is said to be the formulation kept it as a trade secret. It is not protected because what is protection? That means you are filing one patent. That means you are disclosing your invention to the government of India. By the government of India is examining your invention from your disclosure and giving you a patent right. And then the government of India publish in the patent office journal that this is the application of MS Subhangi. So anyone who can come forward to oppose it can oppose, and that is nothing but pre-grant opposition. Or after grant of the patent application, also someone can come and oppose for the patent granted patent called post-grant opposition. If no one come, you are the owner of the patent, but you have disclosed your information of invention, and that was well drafted by the patent attorney and attorney that has been put in place, and that claim with the complete specification is already available in the market. That means I will able to know that Subhangi ji has developed this process and that is her patent. But suppose I need collaboration with you in ethical way, I'm going to collaborate with you and I will pay you some royalty, lump sum premium. That is a process of know-how and technology transfer. But if I am not informing you and doing everything and selling in the market, that is IPR violation. So you can understand the role of patent protection and trade secret.
Right. Thank you so much, sir, for clearing that doubt, and I hope that answers the questions of the audience. In case you have any other questions, you can write to us, or our team will also try responding to it on the comment section below. Considering the paucity of time, these are the only questions that we'll take for now. In case there's any questions from Diksha's side, you can take that up. Otherwise, we can conclude the session for today. Right. So I don't think there's any question from her side for now. Well, on that note, I would like to thank Dr. Sahu for sparing the time today to be here with us, and thank you, sir, for sharing your expertise and your years of experience with our audience today. And I'm sure our innovators and the startups that work closely with us and all the audiences that are watching, I'm sure it will help them expand their business not just in the country but all over the world. So thank you so much and for joining us today. And I'd also like to thank CPAM for very kindly collaborating with us for these initiatives. And I'd also like to inform all the audiences to stay tuned, because we will come up with more sessions related to IPR awareness with CPAM. So in case you have any recommendations on certain issues you'd like us to cover, or certain regulations or topics that you require certain more expertise on, or you require certain more clarifications on, we'd be happy to take that up for the next session. So once again, thank you everyone for joining us, and we really hope that we were able to contribute to your growth journey. On that note, thank you once again.